All right, welcome back. One of the emerging and continually developing areas of law and in civil justice is third-party litigation financing. And you know that we've had panels on this before. We've tried to give a slightly different twist to it this time around. And our steward for this panel, rather than giving you a panel dedicated almost entirely to his docket, as we've done sometimes in the past, we've asked Judge Michael Kaplan to help guide us through this issue of TPLF. Judge Kaplan is a judge on the U.S. Bankruptcy Court for the District of New Jersey, and I will turn it over to him to guide us through the next hour and 15 minutes.
All right, thank you. So our topic is the regulatory and tax treatment of litigation funding, and I'm always hesitant to even emphasize the word tax because, let's be honest, our eyes start glazing over as soon as we hear that. But we're going to focus, and any discussion of litigation funding really involves a conversation about the pros and cons of litigation funding and the need for its regulatory scheme. So back in 2021, the District of New Jersey, I sit in the Bankruptcy Court for the District of New Jersey, our district court adopted a local rule, 7.11, called Disclosure of Third-Party Litigation Funding. And it provided that within 30 days of initiation of litigation, all parties would have to file a statement containing information regarding any person or entity that is not a party and is providing funding for some or all of the attorney's fees and expenses of the litigation on a non-recourse basis in exchange for a contingent financial interest based on the results. And they wanted the identity of the funder, whether the funder had a role in the strategy behind the litigation or settlement, and a brief description. The district court adopts this. They come to me as I was chief of the bankruptcy court. You're going to adopt the same rule, correct? I think that's the way it was phrased. And I said, well, let me talk to my colleagues. And we actually spoke to other judges, bankruptcy judges in the country, and everybody went, what? We don't have, that doesn't impact us. And maybe in a few of the mass tort chapter 11s it's there, but that has no role in our courts. So I'm interested today in finding out whether I was naive when listening to the panelists here, or whether they are going to disabuse me of the need for a local rule for our court on litigation funding. Let me give a brief intro of our panelists. All the way on the right is Will Marra. He's a director at Certum Group, where he leads the Certum's litigation finance strategy. Certum provides litigation funding, claim monetization, a variety of insurances. He's a former law clerk at the U.S. Supreme Court, a lecturer in the law at the University of Pennsylvania Carey Law School, and he co-teaches a course on litigation finance. And he writes regularly. You can go on the Certum website and see several of his opinions, his articles that are there. To his left is Erika Levin. Erika is a partner at Fox Rothschild. She's a member of the international group and leads the firm's Latin American practice and litigation finance group. She's a fellow of the Chartered Institute of Arbitrators, and a significant segment of her practice is dedicated to arbitrating cases in a variety of industries. She previously served as a senior vice president and general counsel for International Litigation Finance Company. And she has taught, and this I like to see, given my Jersey roots, she's taught at Rutgers, international commercial arbitration and international business law. To her left is Phil Goldberg. Phil is an office managing partner at Shook, Hardy & Bacon here in D.C. He's co-chair of the firm's public policy practice group. He's had over 25 years of experience advising liability-related public policy, public affairs, and public relations. He files a boatload of amicus briefs before most of the influential courts, including the Supreme Court and circuit courts of appeal and appellate courts. He's testified in front of Congress. He's an active member of the Lawyers for Civil Justice, International Association of Defense Counsel, give you a little flavor, and the Defense Research Institute. And then finally, to my immediate right is Jim Carter, a principal and policy director at Navigators Global, LLC. Jim recently joined Navigators as a principal and policy director. He's also a senior fellow and former director at America's First Policy Institute Center for American Prosperity. He previously served in the Bush and Clinton administrations as a deputy undersecretary at the Department of Labor, a deputy assistant secretary at the Department of Treasury, and an associate director of the National Economic Council. And what I found most intriguing was he used all of that political experience to help an acting career. He appeared in season 3 of House of Cards playing a U.S. senator. So that's going to be the takeaway from today. So let me start with Will all the way down on the end. Can you give us an overview, an intro to litigation funding, its uses, and the regulatory scheme that's out there at this time?
Great, yeah, sure, and good morning, everyone. It's a pleasure to be here. This is my second time speaking at this conference, and I appreciate the opportunity. We often think of judges as having one of the best jobs, but I think you also have one of the hardest jobs. And so it's a really nice pleasure to be able to speak with you about an issue that I work on, which is litigation finance. I thought I would take my introductory remarks here to give you a little bit of an overview about what it is we're talking about when we talk about third-party litigation finance. In my day job, I fund what I think of as commercial disputes. Things like breach of contract, business tort cases, intellectual property disputes. You might have a claimant that has what they think is a strong legal claim, but they can't afford the $5 to $10 million that it might cost to bring that case. This year, I will see about 400 funding requests from claimants, and I will invest in, take a guess, 12 of those cases probably. So 3% of the opportunities that we see, they undergo an extraordinarily rigorous underwriting process, probably more rigorous than any other type of case that is brought in the federal or state courts each year. The type of transactions that I do are really defined by a question of corporate law. Judge Kaplan read the District of New Jersey rule, non-recourse third-party funding. It's a contract where, as the investor, I don't take an equity or a debt stake in the company. I stand as a third party, and it's non-recourse, which means that if the case loses, I don't recover anything. So I think there's 2 points I'd like to make if you were to take away two points from my presentation. The first is that the practice of third parties funding litigation fees and litigation expenses is very widespread. It's a common and indeed celebrated aspect of our legal system. The second point is that the discussions about, quote, third-party funding regulation are actually only a call to regulate a very narrow slice of that market, and the slice of that market most likely to be used by small and medium businesses or vulnerable Americans. Okay, so the first point, third-party funding is a common and accepted feature of our legal system. I would venture to guess that many, if not most, cases before you involve the litigant receiving some form of finance from third parties, and this should not be a surprise because it's really just a simple capital markets question. Most people and most companies don't have the hundreds of thousands or millions of dollars it takes to perform any of the typical corporate activities or individual activities they might want to do. That's why we have in the United States free capital markets where folks can go for, say, debt or equity capital to pursue their legitimate efforts. There's no exception to seeing this in the litigation space. Start with the ABA model rules of ethics. Rule 1.8F, which has been on the books for generations, explicitly permits and contemplates that third parties will fund the fees and costs of another's litigation and says that this is perfectly acceptable and fine so long as you otherwise respect the legal ethics rules. Okay, so let's get concrete. What are we talking about? The contingent fee. The contingent fee is a litigant who does not have the money it takes to pursue a case, asking a third party to the litigation, their lawyers, to front the fees and the costs of the case in exchange for a share of case proceeds. Thank you. The launch of the contingent fee was actually opposed generations ago by large corporate interests who didn't like that this would increase access to justice by smaller companies that couldn't afford legal fees and case expenses. But imagine you're a larger company. Bayer is a good example. We're going to talk a lot about mass torts probably. Bayer, seller of Roundup, one of the largest companies in the world, and also in a type of case that's the subject of third-party litigation funding. Well, the Bayer Corporation just this year raised millions of dollars, even trying to raise billions of dollars of third-party funding to support their litigation. But what did they do? They didn't call Certum, where I work. They didn't call Burford, one of our competitors. They called their investment bankers on Wall Street and raised equity and debt capital to support their litigation needs. Large companies do this all the time. Small companies do not have access to the type of liquid, low-cost equity or debt markets to raise third-party capital. One more example I'll give you. Impact litigation. Impact litigation brought by 501c organizations are precisely the type of litigations that involve third-party capital. Consider, for example, a litigation brought the past couple of years by the United States Chamber of Commerce to invalidate the FTC's rule against non-competes. The U.S. Chamber of Commerce doesn't sell goods or services. They raise capital from third parties, large companies that don't want to be on the caption, that fund the chamber to then pursue these cases, seeking not money damages, but extraordinarily valuable injunctive relief worth billions of dollars, much more than any case that I've ever funded. Okay, so here are the constellation of third-party litigation funding that exists, debt or equity capital. We're not even yet talking about, because time is short, insurance, defense side insurance, which is not seen as suspect, but seen as best practices for a company to contract with a third party for that third party to bear the fees and the costs of litigation. Okay, so that's the first point. Then very briefly, second, what are we talking about then as part of this debate? It's really not third-party funding writ large. And you can see this in the statutes that are written and the court rules that are written. And one of my articles is coming out in the next couple of months, shameless plug, in the Southern California Law Review, going through some of these statutes. They say, we will regulate third-party litigation funding except. And they have a whole long list of exceptions, consistent with the District of New Jersey rule that talks about non-recourse in exchange for monetary relief. Well, what does that exclude? It implicitly excludes the contingent fee. It explicitly includes companies that are large enough to go get not asset-backed financing, but rather equity investment and general recourse debt, like Bayer went to get. Now, to the second point, to just sort of build that out, who uses the type of third-party litigation funding that I'm talking about? Tends to be small and medium-sized businesses who, when they need the $5 to $10 million it takes to bring a case, Goldman Sachs is not picking up their phone call, but I am. They don't have lots of assets to pledge as security for a loan or to elicit equity financing. So they raise what is essentially asset-backed finance, recourse only to the litigation claim. What defines what I do in comparison to what an investment banker might do is simply a contract. And so my suggestion leading into a conversation about the different types of regulations, which tend to focus on disclosure, as previewed with the District of New Jersey rule, and taxation, is that if we have certain concerns and if we want to target a particular form of third-party funding, we should do it on a non-discriminatory, non-disparate treatment basis, where we address all sorts of third-party funding, not just the one form most likely to be used by small businesses and Americans who can't afford individually expensive lawyers.
Thanks. Well, it sounds so important and beneficial. Phil? What is the defense side view? What's
Sure.
their view of litigation funding and its impact on litigation that we're seeing in our courts?
Well, I'll answer that question, but first I do want to thank the LEC and Donald and others for putting on this conference. Truly, every year, it's truly a great group of people and great discussions, and we hopefully I can continue to contribute to that. I'm remiss that while I did not act on the House of Cards, I am from New Jersey, and
Even better.
I was hoping you would have added that. And I thought, Will, you did a great job kind of laying out a good, section of what third-party litigation funding is. It's largely a new development in what the piece that we're talking about today. I know I didn't learn about it in law school. I'm sure folks here didn't learn about it in law school because it just didn't exist. And if you look at a lot of the writings that people are talking about, and Maya Steinitz is a professor, has done a lot of work in this area, she kind of lays out how third-party litigation funding has fundamentally changed what type of cases are brought, how long they are pursued, when they are settled, and without any kind of transparency or structure into how this market works. The word financing is somewhat of a misnomer, and I appreciate that Will talked about really this is investing. It's not just financing of a claim. It's hedge funds, it's institutional investors who are buying into this lawsuit for the financial return, kind of like they would invest in stocks or mortgages, or instead of doing that, they're going into the legal arena. The form that they take, and I know we've done these kind of programs here for the past few years, but I feel like every year the market shifts significantly. And so originally it was kind of this idea of this non-recourse loan that Will was talking about, and probably that he engages in the most of. But there's also portfolio investing, where underwriting entire portfolios of a firm's litigation, especially in the mass tort space. About 70%, it's been estimated, of the market goes into mass tort financing. There's now asset purchasing. So you're buying you're purchasing the asset of a lawsuit, much like you would other assets. There's articles lately now in Arizona or Puerto Rico that they're buying law firms where they're allowed to do that. And the lawyers who are getting this money are sometimes getting paid a salary to bring the cases, not just funding the underlying costs of bringing the claim. And so there's so many different forms that this is taking, because as it kind of matures as an industry. They're looking at what's the best structure financially, what's the best structure from a risk perspective, what's the best structure from a tax perspective, and then also what's the best structure with respect to trying to avoid some of these disclosure laws that have started to go into effect. You've heard some of the numbers, I'm sure. TPLF has doubled from 2017 to 2021. The major funders have over $15 or $16 billion in assets in U.S. litigation. There'll be over $30 billion by 2028. Those numbers, I'm sure, vastly underestimate what's actually out there, because it's only the major commercial funders, and it's based on self-reporting. My focus, as Will kind of alluded to, is really in the mass tort space. There's regularly north of $50 million, often hundreds of million dollars invested in these, and it is investing through the law firm. So it's not the small or medium-sized business that says, I want to bring this case. It's often the reverse. It's investors and lawyers who decide to build litigations with the money that they're able to spend. And the term has been called vendorization of mass torts, where they advertise a litigation. And TV ads have gone up. If you guys watch TV after midnight, like I do sometimes, I'm trying to go to sleep. You just see ad after ad after ad, or drive on a highway and you see all the billboards. In 2024, it was estimated $2.5 billion of lawsuit ads, up 32% from 2020. And so they build these mass tort litigations that are just too big to fail, because if you have 30, 40, 50,000 lawsuits, and then you can't litigate them all on the merits. And so you end up having to litigate the mass and not the merits of the claims. And so I will say that the funders aren't always looking at the merits of the claim to say, okay, is this a good access to justice case that I want to fund? Is this a good case where I can generate a return on my investment that I can fund? So while there may be an alignment of good access, justice, and good investment, that's not always the case. So historically, this was not allowed. The civil justice system was based on trying to help people resolve disputes, try to bring them to come together, not necessarily to maximize third-party profits. And that the doctrines of champerty and maintenance just kind of foresaw the impact that this could have, but from a negative perspective on some of the abuses that we are starting to see. And so what we've seen in the last 15, 20 years is TPLF kind of go from 0 to 60 incredibly fast, with no regulation, with no restrictions, without any kind of sense of what the impact is having. And here I want to make something perfectly clear. My concern is not about TPLF as a tool for accessing justice. There may be a very good value to that. I think it's here to stay at some level. That's not the point. The point is, and the concern we have, is that when it interferes with the party's access to justice and puts this third-party funder ahead of the parties who are trying to go to the courts to get their disputes resolved. And so my analogy that I look at is like the mortgage crisis from 15 years ago. If you look at all of us, and I know I needed a mortgage to buy my house, I couldn't, take care of that, out of pocket, so I had to get a mortgage. And that is, but when that was aggregated and you can hide the bad with the good and all of that, that's when you get to the abuses, and that's what led to the mortgage crisis. So the goal of a lot of the reforms that we're seeing is to identify and manage the outside investment in the case. So a lot of this deals with funder control of the litigation, making sure that the decision makers, who's in the settlement conferences, are there any kind of ulterior motives? The courts have identified some of these hidden motives behind some of these cases. And the protection here also includes the plaintiff, because unlike the types that Will's talking about, a lot of the plaintiffs in these mass tort cases have no idea that their claim is being leveraged in one of these financial arrangements in one of these investors. So part of the disclosure is making sure the plaintiffs are aware that their case is used in this, and what the impact is going to be on their litigation, on their ability to settle, on their ability to how much of the claim or the settlement are they going to be able to keep versus having to go out to some of these funders. And we've also seen that because in a lot of these situations, the alliance is really between the funders and the lawyers, that the individual plaintiffs really don't have, sometimes studies have shown them they can't identify who their lawyer is, because of their claim has gotten sold throughout the claim aggregation process, that their interests aren't necessarily going to be protected and advanced. And so when we look at the motivation for a lot of these reforms, you're looking at a good governance perspective. So you have outside influence, outside money trying to influence a branch of government. We typically have disclosure, common sense limits, that kind of thing when that happens. Other branches of government have that. And when we look at it as an investment mechanism, we're trying to protect the plaintiffs whose assets are being leveraged, and we're trying to protect the defendants against whom those assets are being leveraged. And then dealing with like the tax treatments, which Jim will get into for sure. So I want to get into a few things in terms of, so we've had, as Judge was talking about, some courts that have standing orders. The District of New Jersey, Delaware are probably the largest two that have them. In Delaware, they saw a 41% reduction in cases the year after they put this in, because the funders would rather direct the cases to places where they can maintain their anonymity rather than maybe where it's best for the plaintiff to have their case heard. In the District of New Jersey, there was one case where there are two law firms, one saying, well, we didn't have to disclose because we didn't take it. And the other one said, well, we don't have to disclose because they're the counsel of record. And so, even though, it's understood that the second law firm is the one that was taking the money, but it has to do, the disclosure rule has to do with whether the claim is subject to the funding, not who is taking the funding or what counsel, if they're primary counsel of record or if they're co-counsel. Then you have a bunch of states that are looking at reforms. In the past few years, Wisconsin in 2018, West Virginia in 2019, again in 2024, Montana 2023, and again 2025. 2024 was Indiana, West Virginia, I already said that one, Louisiana, and then this year, Arizona, Colorado, Kansas, and Oklahoma. And if you look at some of the commonalities, kind of across the themes and the issues that you're dealing with, disclosures is a big one. Disclosing to the parties, the courts, and state regulators. And I appreciate that Will talked about this in terms of kind of like insurance agreements. Insurance agreements are disclosed, and so this should be treated the same way as the general thinking. And it often looks at the control of the funders to make sure that the funders can't control the outcome of a case, that the plaintiffs get to control the outcome of their own case. One of the key issues we're seeing in the Kansas statutes based on this idea of in-camera review, and I know that sounds attractive to a lot of people, like, well, we'll just take a look at the contract and decide if it gives control, if it has, whatever it is. But a lot of the agreements, I mean, some of them do say we control everything. If you look at Lawyers for Civil Justice just filed a comment, they had a whole bunch of contracts they uncovered, and some of them say we control everything, but most of them don't. They say we won't reasonably withhold consent, or they say we can stop funding this litigation anytime we want if we don't agree with how it's being litigated, which gives them control. And so because they're so complex and they're trying to get around these buzzwords of control or other things that might trigger some of the regulatory structure, we're seeing, so allowing the defendant to be able to see the contract and help educate the judges and help educate you about what is in there and how this might be leveraged to actually control the case is something that would be beneficial. And it's typical contract interpretation. You always have two parties arguing about what a contract says, and then you all get to decide what that is. And that's the same approach that we should have here, instead of having an in-camera review where that kind of process isn't allowed to develop, and then also have opinions and appellate rulings and all that to have access to kind of establish a baseline. There's also issues of privilege of the plaintiff's information that gets turned over to the funder, and privilege related to the defendant's information, whether it's...
So let me
Yeah.
stop you there, because I was going to ask Erika.
Sure.
Well, yeah, you have to stop. But before I ask, we're going to get to some of those issues.
Mm-hmm.
But I did want to ask Jim a question. In a little different tact. What I'm hearing is that litigation funding is an investment vehicle for many. It's an asset. Now, over the past, let's say, 5 years, our court, the federal courts, and my court especially, we've seen 10 to 15% budget cuts each year. It's impacted security, it's impacted IT, efficiency, a host of good people have been forced out because of these budget cuts. Yet we have, our courts are a marketplace now, where people are making money from the outside, third parties. And at the risk of sort of reflecting my Jersey background, should there be a VIG coming to the courts in the form of taxes, as far as income taxes on the money that's being made? Can we wet our beaks?
Well, that's a good question. And I will address that. But first, I just want to thank Mason for the invitation to speak here today. And I say this especially because I earned my master's degree here at Mason 32 years ago last May. So it's good to be back. So thank you. And of course, we've heard a lot this morning and in recent months about third-party litigation funding. So what can I add? Well, my focus today is going to be on the politics in Washington, D.C. of this, and perhaps outline what might happen in the months ahead. Now, one of my favorite quotes was from Groucho Marx, Groucho said, sincerity. If you can fake it, you've got it made. Now, well, sadly, I can't fake it. I won't even try. But I'll just tell you as I see it. Those who take issue with third-party litigation funding routinely suggest reforms. So if politics is the art of the possible, what is possible? Well, from my perspective, there are at least two things we'll see shortly. First is disclosure. We've heard a bit about disclosure. Polling indicates that requiring third-party litigation funding disclosure is widely popular. People want to know who's funding these seemingly endless and very costly suits against U.S. companies. Ultimately, who pays? Well, we all pay. One poll conducted by the U.S. Chamber's Institute for Legal Reform found that 79% of Republicans and 79% of Democrats and 81% of independents favor disclosure. And of course, having worked in D.C. For 30 plus years, and as was mentioned in the White House, both as a Clinton appointee and as a Bush 43 appointee, I can tell you now that an 80-20 issue is ripe for action. Meanwhile, as has been mentioned, some judges are taking action to require TP-L.F. Disclosures in their district courts. And state lawmakers are increasingly aware of and working to mandate these sorts of disclosures. So that's the first. Secondly, the T word, the dreaded T word, taxation. So TP-L.F. contracts are often structured to claim capital gains treatment, enabling foreign investors to extract litigation-based profits from U.S. courts without paying U.S. tax. Plaintiffs, by contrast, are generally taxed at ordinary income rates on any taxable award they receive. Now, correcting this loophole by forcing foreign-based litigation funders to pay the same U.S. tax as American plaintiffs pay would promote tax fairness and reduce harmful incentives. Now, enter Senator Tom Tillis. Senator Tillis introduced S. 1821, the Tackling Predatory Litigation Act. His legislation has 4 co-sponsors in the Senate, but is far more prominent than it appears. You also have Kevin Hern, a member of the House Ways and Means Committee, with a bill. It's a House companion bill to the Tillis Act, H.R. 3512. It has 14 co-sponsors. And I should mention that Hern is the chair of the House Republican Policy Committee. And many of the other co-sponsors are on Ways and Means. So that's the committee that will deal with this. You may also recall that Senator Tillis's proposal was, at one point, included in the reconciliation bill Congress considered earlier this year. Now, reconciliation bills are very powerful legislative vehicles. They empower a congressional majority, even a teeny tiny one like exists today, to avoid Senate filibusters and, if necessary, pass legislation along partisan lines. But as powerful as reconciliation is, it is subject to restrictions concerning extraneous, quote-unquote, provisions. Those restrictions are commonly referred to as the Byrd Rule, after the late Senator Robert Byrd of West Virginia. If the Senate parliamentarian determines that a provision violates one of those restrictions, legislators typically rewrite the provision to comply or drop it out in order to maintain the reconciliation bill's protected status. Again, allowing you to pass with a bare majority. Now, the Senate parliamentarian determined earlier this year that several provisions proposed by Republicans in the reconciliation bill, the one big beautiful bill, as President Trump put it, violated the Byrd Rule. Some of those provisions were rewritten to comply, others were dropped. Of the provisions forced out by the Senate parliamentarian, the provision addressing third-party litigation funding is a no-brainer for inclusion in the forthcoming rescission bill that we may have later this year. Now, there are at least 3 reasons why I think we haven't heard the last of Senator Tillis's proposal to change the way we tax third-party litigation funding. First, as the former director of the Center for American Prosperity at the America First Policy Institute, I can say that this proposal fits very snugly with the America First priorities that this administration and the majority in Congress are pushing. And given that nearly 100 of my former AFPI colleagues are embedded throughout the Trump administration, I suspect it'll be supportive of that effort. Secondly, Add in the fact that the Joint Committee on Taxation, the official scorekeeper for the fiscal impacts of tax legislation, it says that the Tillis proposal would raise at least $1.5 billion over the course of the budget window. I've seen numbers as high as $3.5 billion. So, and of course,
That would help.
that would help. And of course, Republicans are notoriously opposed to tax increases. But Americans for Tax Reform, also known for its opposition to tax increases, recommends closing this loophole, going so far as to highlight it in a report titled, and I quote, "List of Good Reforms That Raise Revenue for Trump's Tax Cuts," unquote. So, and then thirdly, having adopted President Trump's One Big Beautiful Bill by the narrowest of margins, congressional Republicans are hoping and preparing to advance a second reconciliation bill and perhaps a third one next year. Indeed, Senate Finance Committee Chairman Mike Crapo of Idaho wants to write a second bill. He wants a second bite at the reconciliation apple. As remarked earlier this year, quote, "We didn't clear the deck in the last bill," unquote, adding that Republicans had hoped to include over 200 tax policies in the bill, several of which were dropped. Again, third-party litigation funding has taken off, has been mentioned here. It's a multi-billion-dollar industry. The U.S. commercial litigation finance industry managed $16.1 billion in assets across 42 active capital providers from mid-2023 to mid-2024, according to Westfleet Advisors report. And the market is expected to grow to nearly $26 billion by 2030. So why is TPLF market growing so rapidly? Well, it's extremely profitable. Two illustrative cases highlight the strong return potential of litigation finance. Apex Litigation Finance, with a 12% market share, has funded 500 cases, averaging $400,000 each, with a reported success rate of around 70%. Apex's selective approach to case underwriting has yielded an average return on investments of 30%. 30%. Similarly, Longford Capital Management raised $56.5 million for its first fund, which focused on claims involving contracts, antitrust issues, and other commercial disputes. That fund delivered impressive early returns, reportedly ranging between 70% and 90%. So given its profitability, TPLF is understandably fueling a surge in legal advertisements, as was commented on here. Foreign hedge funds and sovereign entities, meanwhile, are increasingly using TPLF to take advantage of U.S. courts to extract billions of dollars annually from American companies. And to make matters worse, they do so while routinely avoiding U.S. taxes. And shockingly, that's legal. So TPLF has evolved into a product with characteristics more akin to private equity than legal aid. Its growing footprint in commercial litigation raises concerns not only about transparency, fairness, and judicial integrity, but also about distortions created by the U.S. tax code. The Senate parliamentarians' unilateral, unchecked decision to tank the TPLF provision dealt a blow to its supporters, including a coalition of 18 center right organizations led by prominent taxpayer watchdogs like Americans for Tax Reform, the National Taxpayers Union, and the Taxpayer Protection Alliance. More than 50 companies and associations representing a broad cross-section of the economy also lined up behind this tax fix for profit-seeking foreign entities, flooding U.S. courts with lawsuits, making it a slam dunk for the Trump administration and Congress's America First agenda. So if the 119th Congress takes another bite of the reconciliation apple, pursuing TPLF funding tax reform is a no-brainer. Thank you.
Thank you, Jim, for your clearly objective view.
Always.
Now, Erika, with the burden going last, I'm going to give you the benefit of being able to respond to any and all of this. But I am interested, your background, you're very much involved in arbitrations and also litigation funding, even on the international level. If you could touch on those, I think it'll give a broader perspective of litigation funding and its impact on our courts.
Sure, and thank you. I want to thank the Law and Economics Center and Donald for having me. This is my first time here, and thank you for being here. You do not have an easy job. I have interned, I have clerked, and I serve as an arbitrator, which is not the same as being a judge at all. I've been counsel as defense in Magic Circle big firms. I've been counsel as for plaintiffs, and I also serve the unique role. Part of what I think I can impart here that's a little different from others, and I will be as candid and I will help you understand and demystify the shroud of mystery that has been over this area. And I thank you for the question, Judge Kaplan, because really, we've been studying this area for a really long time. I was general counsel for a litigation finance company over a decade ago. I participated in the ICA Queen Mary task force focused just on this third-party funding litigation. And through the years, the nomenclature changes. It doesn't make it easier for you. So it was third-party funding, third-party litigation funding, litigation finance, legal finance. The nomenclature has changed, and there's a lot of variety. You've even just heard today. You heard Will talking about commercial litigation financing, right? And you heard Phil talking about mass tort aspects. There's a big variety. There's been contingency aspects that have also fallen in. One of the hardest things that we had to deal with in the ICA Queen Mary task force was, believe it or not, coming up with a definition. It took a really long time. And this is just to kind of put this on the side, and I'll come back to it. It's what Will alluded to. I don't think that there's any problem in discussing this, helping you understand it. As regulatory efforts are undertaken, whether it's through the court, through the legislature, in terms of the rules, I am from New Jersey, proudly. It's not so much disclosure, so to speak, but I just want to make sure that you understand. What's all the fuss about? What's really going on? And from my perspective, just so you understand, I touch all facets of litigation finance. And I have to say I'm here on my own behalf. I don't speak on behalf of my firm, anyone else, all the caveats. But what have I seen? I represent funded parties negotiating these transactions. I have worked on the deals for law firms. I've worked with respect to deals for the funders. I've probably, out of this room, maybe Will has seen more, I don't know. But I've seen more of these transactions, documents, contracts than anyone. So I can tell you what I've seen and I can demystify it a little for you. Before I do that though, I want to just pause. What's all of the fuss about? We're advancing justice. That is your job day to day, right? And that is important to you, it is important to me. But we also have to balance the concerns that are raised. So when we have criticisms and they're not addressed, we get more concerned. We've seen that over the last few years. In the arbitration context, and the reason I bring this up is not that arbitration and court are the same, so to speak. It's only because the litigation finance regime started in Australia, went to the UK, and then has come here to the US. And I'm a big believer in studying history and understanding what the concerns were, how they were addressed, and how they fit what's happening here or not. Arbitration, again, is a distinct animal. International arbitration itself is distinct. But there's aspects that we dealt with. And one of the things that I think is important for those that are really interested is look at some of the studies that were done in the UK. Not that the UK system is exactly the same. They have loser pays. Up until more recently, there's been a lot more restrictions on contingency. But you have leading justices like Lord Justice Jackson, who wrote the Jackson Review in 2009, finding that funding was beneficial and should be supported. Why? It promotes access to justice. We even have cases as far back as 2014, Miller v. Caterpillar, where they found that it evened the playing field and advanced justice. One quote for you. Where a defendant enjoys substantial economic superiority, it can, if it chooses, embark on a scorched earth policy and overwhelm its opponent. But even where a case is not conducted with an ulterior purpose, the costs inherent in major litigation can be crippling, and a plaintiff lacking the resources to stand a long fight may be forced to abandon the case or settle on distinctly disadvantaged terms. So it's important for you to understand that, I think you understand this, you've practiced, I'm sure, before you went on the bench. Access to justice is not free. In fact, it's very expensive. Unfortunately, I don't know how we fix that, right? That's the problem, but the finger is getting pointed at the funders. We'll address the control issue, we'll address the disclosure, but really importantly, I want you to just take into account the access to justice issue, at least from this perspective. If those harmed are not able to bring their lawsuits They won't be reimbursed for their harm. That's a denial of justice. Under enforcement also results in a lack of deterrence. Will mentioned how few of these cases actually get invested. I will tell you, as someone who works on these transactions, who receives the call from parties who want to bring a suit, it's not just the merits. No, the merits have to be there. If the merits aren't there, we're not talking. The merits are the first piece. But there has to be a profile that makes sense. And really, the funders are playing a gatekeeping role in some senses. So the question that's always asked is, does litigation finance encourage frivolous litigation? I've heard this accusation numerous times. And in fact, I have to tell you it doesn't. Why? Because when I am working on a deal, I will tell you, and this is the other issue, we need more statistics, but the average number of deals that go through and executed are probably 5 to 10% of the 90% that are presented. When I sat in that capacity, there were a lot of conversations we undertook, a lot of hard stories that I heard, but we couldn't get involved in all of them. And the investment aspect, I know that's the piece that people look at and it doesn't feel comfortable, but what you have to understand is these are the smaller guys. These are most of the constituents probably for the legislators. Maybe these are the guys that if guys and gals, without this, they won't be able to bring the suit, right? One thing I think that is super important to realize is we're talking about meritorious litigation and meritorious claims. There are breaches that have occurred, there are harms that have occurred, and without the ability to have their day in court before you, they don't have a chance. What happens then? That encourages faulty, bad behavior. It encourages further breaches. We need the deterrent effect. We need the day of the right for people to access the courts. That's not to say, frankly, though, that they necessarily win. One of the aspects we've heard a lot about is transparency and disclosure. For what purpose, I ask, right? I'm not against disclosure. Again, I speak on my own behalf. What I advocated throughout the years was in-camera review. Why? If there is a concern, you can disclose, but disclose what? And if you really, really are concerned, then perhaps an in-camera review is relevant and helpful. But the threshold that has to be undertaken here is for what purpose and why. Do not allow disclosure to be a Trojan horse. What I've seen in practice, this is me putting on my lawyer hat, is disclosure has become the beginning of an end. It is another aspect that further drives up the costs, right? So what happens? There's an instance where there's a disclosure, and then in the US courts, where we have ample liberal discovery, which has its benefits, I will admit, there becomes a discovery sideshow. So this person, claimant, plaintiff, has a budget that they've been given, and now that budget is going to be decimated by this discovery sideshow. That's the problem I want you to understand. It's not that I have a problem with disclosure. If you want disclosure, disclosure with guardrails, but understand what happens after. Make sure that that's done carefully, because otherwise it erodes the whole access to justice benefit that we were going for. There's other aspects in terms of disclosure that have been raised, and I can't go into all of them, but in terms of the conflict of interest, if that's really a concern or a control issue is really of concern, that can be addressed. What I'm trying to avoid is irrelevant conversations that only further make the obstacles harder for the other side. I know that I'm short on time, and we'll get to address all of these questions and issues, and we can speak after as well. The key point that I want you to remember is, in terms of these discussions that we've had over time, what we found is that the funders do not control. I've seen these agreements. They specifically have provisions that say the client controls. Are there tensions? Are there potentials for conflicts of interest? Yes. Part of why I'm involved as independent counsel a lot of times is exactly for that. What happens if those things are not provided or protected for? The agreements are unenforceable, so the investment goes awry. The non-recourse investment, right? It doesn't happen. And lawyers and law firms are also held responsible by the rules of professional conduct. A law firm or a client undertaking litigation finance, even if it's the client doing it with the law firm, that is not undertaken lightly. There are a lot of ethical concerns that are analyzed really strongly. I see that I'm out of time, so I'll pause here, and I think we can have a little more of a discussion. But I really want to thank you for taking the time out of your busy schedules to sit here and listen. And again, however I can be helpful to further educate more broadly, I'll put on my teacher academic hat. Please know that I'm at your service, so thank you.
Thank you, Erika. And I'd like to give the panel a chance to start responding, continue
Sure.
what we hope for as a dialogue. I have a question at the outset, and it was for Will, because with his presentation, he mentioned Roundup litigation, Monsanto, and it struck me as odd because we think of litigation funding plaintiff side mostly. And I'm curious as to the use, how prevalent, if at all, is defense side litigation funding? And how is it structured? What's success?
Yeah.
So, if you
Sure.
could touch on that.
So I think the way I would answer that question is defense side litigation funding is best practices for large companies, and it's called liability insurance. That companies engage in these types of contracts all the time. They pay for insurance, and then if they are sued for wrong, the insurer comes in, controls the litigation, and pays the fees and the costs of the defense side. Now, I understand there's an argument that, well, if insurance is disclosed, funding should be disclosed. There's a little bit of an irony in this argument, though, because we all accept and agree that insurers should be able to control the litigation on the defense side, whereas disclosure is sought for the plaintiffs precisely to ferret out and make sure that, control happens on the defense side, whereas we seek disclosure on the plaintiff side to ferret out whether control is actually happening because it's supposed to be a bad thing. A couple of notes, if I can, just to quickly respond. Mass torts are a very interesting space, and the history of mass torts really dates back to a couple of 1990s U.S. Supreme Court decisions called Amchen and Ortiz v. Fiberboard. What do we think about when we think about cases with thousands or millions of claimants? We think about class actions, right? That's the typical mechanism, Rule 23. Well, the Supreme Court ruled in a couple of cases in the 1990s that cases with individualized harm are not well fit for the class action mechanism. So if you were injured by, or think you were injured by Roundup, or at Camp Lejeune, which has been approved by the US government essentially as a group of folks entitled to compensation, you actually have to know about your rights, and then you have to go file a case. So most cases that have thousands and thousands of claimants, you just have a single case filing and it's the class action complaint. You can't get access to justice in a mass tort unless you know about your case and you get on file. So what's happening in the mass tort cases is you have lots of people that do have good claims that maybe don't know about it. One quick note, if I can, on the tax piece. It was framed as sort of an issue about foreign interference. The tax applied equally to U.S. and foreign funders, so it was not limited to foreign funders. The tax was a 40% tax with no right to offset gains and losses, and a tax at the entity level that resulted in double taxation. So we don't have to get into the details, but the effective tax rate is probably like 80%, which is sort of unheard of in the history of taxation in the United States. For comparison, because an argument is made about, well, treating other types of claimants in a comparable way, if you're a mass tort plaintiff, you're getting compensatory damages, your tax rate is 0%. So any funding you need is coming at a higher tax rate because you can't access the courts. If you had the money that these people don't have, you're not going to go through third-party funding and essentially pay a higher rate. Likewise, I looked up this morning, Intel and Meta both had about $50 billion of revenue last year. Their effective tax rate was about 12% for Meta, 0% for Intel. So what's happening here is not an effort to sort of establish comparable tax rates. It's really an effort to dissuade a particular type of financial transaction.
Thanks. Well, Will's had his chance to respond to a few points. Other panelists want to raise any issues or take issue? And as to the audience, if you have questions and you're interested, we could start lining up.
I'll just say on the mass tort question you just raised, I think, you mentioned that, if you have a meritorious claim, then you should have your case heard, and I couldn't agree more. The issue is not having meritorious claims. The issue is making sure that at least somebody has a colorable claim in the mass tort context. It was interesting. I was at a conference about 2 weeks ago that the American Law Institute held in New York on kind of these issues in the MDLs. And I saw something for the first time that I last saw about 15 years ago, and when you had asbestos litigation, we had 90 or 100,000 claims of these unimpaired claims being filed, and you had some plaintiffs' lawyers at that hearing, at that conference a couple weeks ago, who are very well respected plaintiffs' lawyers and are known to having good cases, saying, yeah, we probably need to have early vetting in MDLs, because when you have all this funding that comes in and the advertising of claims, and people can click through or they call and their claim gets on file, no one has vetted that individual claim as if that person went to, that was injured, went to a lawyer, and the lawyer's deciding, am I going to put my own money, or even if I'm getting financing, and doing the kind of individual analysis that they're talking about that they do when they're deciding whether to give money to to a business or somebody to bring a claim. Here, that claim gets filed without any of that vetting. And so the key issue in the MDL context is making sure that you can get early vetting, at least show that they were exposed to the substance that's at issue in the litigation, and show they have the injury that's at issue in the litigation. If they can at least show those two things, then they get to be in the MDL. The problem is, studies have shown somewhere between 20 and 40% of cases that are claims that are filed in the MDLs can't show either of that, or can't show both of those things. And so a lot of times these cases get scheduled to be worked up for bellwethers, then they get voluntarily withdrawn because they can't show that they actually belong in the MDL. And so I would agree with you that let's focus on the ones that have merit, and if this provides access to justice for that, that's one thing, but it's where it interferes with access to justice is where we're talking.
Erika, if there is a concerted effort by litigation funders to first make sure there's merit in the underlying litigation, and they're doing their due diligence, how do we guard against or ensure that flow of information doesn't violate attorney-client privilege, confidentiality issues, work product, et cetera? Because I would think litigation funders want access to as much information as possible, and that do we run into problems in that regard?
So it's a very good question, and I will say there's a lot of care with respect to NDAs, non-disclosure agreements, work product, and common interest privilege. And I think over the years, and the Miller case I cited to before was one of the premier cases that was helping to safeguard against the protection. But you're right, the lawyers are under an incredible responsibility under the rules of professional conduct to safeguard their clients' confidential information. And so there's a balancing act, and there has to be a way to approach this so that we can be working with the clients, preparing the information so that the diligencing can occur, right? It's really important, and I'll say this for this audience, that those non-disclosure agreements and those protections are protected. Otherwise, the access to justice isn't available. And the last thing a lawyer wants to do is violate a rule of professional conduct. But if they don't undertake the process of engaging with the client and or with the funder, they won't be able to access or help unlock the funding. Traditionally, just so you know, the way that we operate and the way that we handle it, it's on the client. The client has to be the one in communication, right? And there's a fair amount that can be done in terms of discussions where it can be done protected, but it's definitely a concern.
Now, my understanding is at times funders are designated non-testifying experts. Is that done at all, just to avoid work product issues with information? Have you seen that?
I can't necessarily comment. I would imagine Will can comment more on that.
So, so most courts have held that communications with funders are either not relevant under Rule 26 or are protected work product. The best decision on this, I think, is a decision from Circuit Judge Bevis, sitting by designation in the District of Delaware, Design with Friends versus Target. Rule 26 has a very capacious definition of what is work product, and certainly any communications by a lawyer, attorney, to a funder would qualify as work product, and that's, I think, almost universal among the cases.
Thanks, Will. Let me go to the audience.
It seems to me that third-party financing is like the first cousin of a contingency, a lawyer's taking a case on contingency, except that the types of cases that a lawyer takes a contingency case on are different than third-party financing, because the latter involves a lot more money that's involved in a case that a lawyer on his own or her own is incapable of financing on their own on a contingency basis. But my question to William is that with respect, you said normally the the client is not the one that comes to you initially. It's normally the lawyer for the client who is contemplating taking the case, but realizing that he or she can't handle the financing involved. Is that correct?
About half of our agreements are with the law firms and about half are with claimants. The typical fact pattern, Judge, is client calls lawyer, says, I have a great case. Lawyer shares their fees. I can't afford to pay you. Why don't we go talk to someone who can help? So it can be either.
All right. But from my perspective as a judge, the only concern I have, if I'm not aware of the third-party financing and a case is ripe for mediation or ripe for arbitration, basically the client doesn't necessarily make the decision as to whether or not to accept a settlement or accept an arbitration. It's your company that makes that decision, right?
That is not correct. All of my agreements, and I've seen 100 of them, it actually explicitly disclaim control, say that we do not control case settlement, we do not control case strategy.
So in other words, if a settlement offer is made by a defendant in a particular case, he or she or their lawyer has full discretion as to whether or not to accept that without your approval?
Absolutely, 100%. And in 100% of the cases I've ever funded.
Does that happen frequently?
It happens every case, if there's a settlement.
And if I can add to what we've seen over the course, at least for me, over the last decade, and this is why I'm saying disclosure isn't always bad. When we've had disclosure in certain contexts, it's actually led to settlement. Why? Because once you get over the myth that litigation funding is actually encouraging frivolous suits, and you understand the careful attention that has been and diligence that has been undertaken before that happened, you realize that the case is sound. It's meritorious. And so that invites usually a discussion, in a settlement discussion. So in effect, and this is why I said this point about disclosure with guardrails and be careful. Those facts in terms of encouraging settlement were happening in a civil law system more so, because they don't have the same access to discovery and they didn't have that issue. That's not to say that disclosure as per se in terms of with guardrails can't be a positive. Because if you know, as a defense lawyer on the other side, someone has vetted this beyond belief and they're still here, I better take this seriously. Maybe instead of spending millions of dollars on my defense, we should get to that settlement table earlier, right? And we should talk and actually figure out what it is that we can do. Again, litigation is expensive. A lot of it also is brought by the defense, not getting to that table early enough. So I'm all for settlement. I'm all for the earlier discussions. And in fact, all of this comes in that context that work, a lot of it has been done. And if that case is there and you find out there's funding, settlement talk should be encouraged. Now, whether it takes two to tango, right? Whether you're getting to the right point or not. But what shouldn't be happening is litigants or people with claims shouldn't be restricted or prevented from bringing their suit because they don't have that money or those resources. And they also shouldn't be forced to take a settlement that's way too low, that doesn't make sense. So that's the balancing that happens here. And I understand there's concerns in terms of mass torts. And what I'm urging is take the concerns and put them in the proper buckets. Let's categorize them and unpack them. I can't speak to the mass torts as much because I do primarily complex commercial litigation. So what I'm talking about are people who've had issues with a breach of contract against a bigger party, more well-resourced, well-funded. And so there's a disproportionate asymmetry there, right? It's not possible for them really to take that on unless they have some help. And unfortunately, there are a lot of times where I have to say no because I can't get through the hurdles with them to help. That's unfortunate.
Just to follow up on your question, LCJ just filed 7 contracts with the Federal Rules Committee. I'm happy to send them to you if you would like. One of them literally said, we control day-to-day instructions. Another one said they must adhere to the project plan that the funder provided. Most people who've been at any of these conferences heard about the Syngenta case, or they said we won't unreasonably withhold, and then they withheld, and then they stood in for Syngenta in the litigation. And so the problem of control is very serious, and it does interfere with the ability of parties to resolve their dispute. I mean, they had ongoing relationships with the meat packers and the meat suppliers, and they didn't want to get the most amount. But Burford in that case was trying to not just maximize money for that case, but then set a settlement dollar for future cases they were planning to fund. And so that's why they didn't want to accept the settlement that they were willing to take. So I appreciate Will's comment that he doesn't do that. That's great, but that's not always his practice. Aren't necessarily running
My last question is the problem having the issue grasping is that, say the case has been going on for like 2 years, 3 years, and a significant amount of money has been expended by the third-party financing company. Yet the offer for settlement, which the client, after being involved in the case for 2 or 3 years, has had it, doesn't want to just carry this thing on any more time, and yet the offer that he or she is inclined to take is significantly below the amount of money that has already been financed by the third-party financer. Does that create a conflict?
What I would say to that is there certainly may be situations where the claimant may not want to take a settlement because of the funder having to get a return. Cases sometimes do get impaired. A lot of agreements are actually just renegotiated to make settlement happen. We actually love for settlement to happen for a whole bunch of reasons that I can go into. What I would suggest is that this concern is not unique to what I do, right? Questions about third parties controlling litigation who are undisclosed, frivolous defenses being raised on the defense side. This is universal. I mean, this morning I looked up, I thought, well, OpenAI and Anthropic, right? Huge companies involved in major litigation. What's the disclosure that happened in those cases? I think one of them said Microsoft's a shareholder, one of them said Google's a shareholder. I mean, the cap tables of OpenAI and Anthropic and the number of people not before you in a case who are going to have a say on whether OpenAI and Anthropic settle a case, it's enormous, right? So these types of concerns, I'll embrace that they happen sometimes. My suggestion is they are not unique to what I do. So if we want to address that problem, let's address it wholesale. Let's not do it with just a very specific set of transactions.
Thank you.
This
Go ahead.
actually piggybacks on the question from my learned colleague. I heard about the disclosure between the attorney and the client, but is it also disclosed the financing by third-party litigation to the court? Namely, would we as judges who preside over the settlement, would we be made aware that the case is financed by third-party litigation? And similarly, if it's a jury trial, is it something that's disclosed to the jury, especially on a case for damages?
So on the reforms that have been enacted in the states and in some of the district courts, the answer would be it should be disclosed to the client, to the plaintiff, if the lawyer is the one who took it. There's different levels of disclosure to the court depending on which state and which reform. Some, like Kansas, is in camera review. Others are full disclosure, and some are you provide to the other side. that has nothing to do with admissibility of evidence on a claim or defense.
Right.
And that's part of what the debate here is, because when you get to discovery of the agreement, the argument against it of discovery is, well, it's not relevant to a claim or defense, and so therefore it's not subject to discovery. But it might be relevant to the rule that's at issue, whether it's in the District of New York or under one of these states, that it's discovery related to that, to the requirement to disclose. And so that's where you get the push and the pull right now in some of these, in some individual cases where the defendant files a discovery request to get the document under the rules that are supposed to apply to that case. And the plaintiff's attorneys argue, well, it's not relevant to a claim or defense. Now, that is the exact same debate that happened in the 1960s on insurance agreements, which is why you have the insurance rule to say, it doesn't matter if it's relevant to the claim or defense, you have to disclose it. And that's why a lot of the defense community is saying to the Rules Committee, treat this the exact same way, because the exact same arguments that came up, 50 years ago in 1970 when you enacted the rule to disclosure on insurance agreements, it's the same arguments that we're seeing here today.
So I'm in New York, so unless it's on consent, if you will, or it's deemed to be discoverable, I could technically preside over a settlement and be unaware that there's this third-party financing, right?
Correct.
Okay.
The one distinction, though, I think that's important to draw, and again, I like history and I like to learn from where we were. The distinction in the insurance context is they do maintain control. And so on these aspects that we were discussing before in terms of settlement and the like, the insurer will decide whether or not to settle. The insurer steps into the shoes of the litigant. And in these litigation funding scenarios, that's not the case, right? The client themselves will be the one that decides. They'll consult with their lawyer, they'll talk, they'll think through it, but they're the ones who retain the ultimate control. And in terms of just figuring out how that works, it's a little distinct. The other problem that we see sometimes is if too much information is given in terms of the quote unquote war chest or how much there is or what's going on, that also leads to more problems in terms of how things are going to proceed. So I understand that there's concern. As a judge, you want to know what's happening, right?
Right.
And I think that's valid, and there's aspects where we can curtail that. We can help you with that. But it has to be done in a balanced way. And I want you to understand the distinctions between what's been happening in the insurance context versus what's happening in the litigation finance context, because they're distinct.
Thank you.
Thanks. Last question, Mark.
Very quick question, because I wanted to address an argument that was made by the proponents of funding is that we don't fund frivolous litigation because it would be bad business to do that. But I think there's a distinction between the truly frivolous and speculative, because what we're seeing, if you take even just, I wrote an article plug in the Cornell Journal of Law and Public Policy this year on third-party funding. But in the ovarian talc cases, for example, J&J's won like 96% of those cases. They only lost one, but they lost for $2 billion. So if you're in a litigation where you lose 18 out of 19, but on the 19th case, you make $2 billion, that's going to continue these types of cases. So you're going to have lots of tort cases that go forward where 95% of them are meritless. But because of the incentives by the funding, they're going to continue because you only have to win 1 in 20. So I don't know if anybody had any thoughts about that, the difference between frivolous and speculative lawsuits.
Sure, I'm happy to take it. If I was right 1 out of 20 times, I would be out of a job immediately, is maybe the kind of real politic of it. I mean, stats were provided earlier about 70% win rates. I think there was a quote in there which I quite liked about their extensive underwriting. That's not a sustainable business model, just respectfully. Because our funding is non-recourse, we get $0 if we lose. So we need a lot of winners and a lot of really big winners. Then there's this other question, by the way, on the mass tort. And mass tort is very complicated, very interesting. But mass tort lawyers have been around, since the dawn of time. It may be that the economics work out that way if I want to accept the premise for a contingent fee lawyer. That doesn't mean a litigation funder is going to back those cases, and you can kill litigation finance and your mass tort filings are not going anywhere. They're going to stay exactly the same.
I think it's time for lunch. Thank the panel. Thank you all.